Well, John and Colleen, thank you for having me. Hopefully we can kind of give you some basics as to what it means to get divorced in Connecticut and the different models that you can choose to undertake in terms of the divorce process. And, you know, as Colleen said, to give you some background, I initially went to undergrad for a psych and social major. And following that, I went on to do my first year of my MSW. So I'm much more inclined to be a therapist like Colleen is than a lawyer. But I didn't feel that I wanted the dual role. So after managing rock bands for a couple of years, I then went back to law school at night. Started out in the litigation world, in civil litigation. And one of my partners asked me to help him out in family law. And I kind of said, why would I want to do that? But the minute I got integrated into family law, I realized it was kind of the right thing for me, because I think it's a good blend of counseling and law, because divorce is not an arm's length transaction. It's not a typical lawsuit that you would have between two, third parties. It addresses a family, and a family dynamic is much different than any other consideration. It's different than a landlord-tenant. It's different than a business dispute. It's different than a contract collection, because even if you're going to dismantle the marriage, I really think you need to restructure the family. The default for any legal action in Connecticut is litigation. And as an attorney, you're trained to be a zealous advocate for your client. And in theory, that means to disregard the other side, that you shouldn't be interested in their point of view, their perspective, their concerns. The difficulty with that is you are a family unit. And even if you were to get divorced, the vast majority of people still have ties together, whether it's because of extended family or children or anything else. So I guess I'd begin by telling you why I don't think family law is well situated in a litigation context.
Okay.
If you compare it to medical malpractice, there's a standard of care. And it means that if you go in for a procedure with a doctor, and the doctor fails the standard of care in that he does something negligent, then the person who suffers is awarded their damages if they can prove negligence. If they can't prove negligence, they get nothing. And if they can prove negligence, then they get compensatory damages to hopefully make them whole. Well, that's a lot different than a family situation. A family situation is ongoing. It's dynamic. No one's going to win everything or lose everything. No one's going to walk away with 0, and no one's going to walk away with 100%. So, there's what we call like a reasonable realm about how people are going to settle a family case. In Connecticut, there are very few things that are formulaic. Basically, the only thing that's formulaic is child support guidelines. That's where it takes into account both parties' income, certain expenses and deductions, and spits out a presumptive number. And that presumptive number can be deviated upon for different reasons, but it's basically a set number for child support. But alimony, for instance, is completely different. Alimony, you negotiate the term, how long it is. You negotiate how it's to be paid, whether it's a flat sum, whether it's a percentage. So that there's a lot of rules of thumb, but again, it's not formulaic. So divorce involves a lot of negotiation, very clear-cut rules for the most part. And therefore, the model that you pick is very important. So as Colleen said, the traditional, the default, unless the parties agree, is for litigation, where both attorneys are acting as zealous advocates only for their client. And it can be destructive to some extent, or it can at least be polarizing. And what happens is people become very invested in their storyline. I had clients that had spent 14 months in litigation, and then they came to me for mediation. And I think we resolved their issues in 6 weeks. And the difference being, when they first approached me, the husband said, our attorneys are so focused on the story about what brought us here. And he said, you know, we both know what brought us here. We both know we had some involvement for the breakdown of the marriage. And we both know that there's a lot of unknowns and a lot of disputes. But instead of looking backwards and throwing blame, we want to be forward thinking and say, how are we going to move ahead? Not how is everything that happened in the past. So, you know, there are essentially 3 different models, and any party can represent themselves at any time, pro se. So even if you're in the traditional model, it does not mean that you can't represent yourself. It does not mean that you need to have attorneys involved. John, is it possible for you to make me co-host for this for a second?
I'll give it a try. Give it a try. Let's see.
I have a diagram that I use a lot.
Yeah,
I think it might be helpful.
Yeah. Okay. So you can't share your screen now? You're not seeing that?
I couldn't a minute ago. Let me see if I
okay.
can now. Nope, not as of yet.
Okay. I've just made you a host.
Oh, there you go. All right. Let me see if I can do this for you. So as I said, litigation in theory means 2 parties are oppositional to one another. And that therefore, sorry, I'm trying to do this at the same time and I'm not that skilled at it.
Yeah. We're not seeing your screen yet.
Yeah, no, I'm gonna pull it over into a different screen because, you know, we're all fearful of the idea that you're going to mistakenly expose client confidentiality. So we always have to be very careful about this. All right, here we go. All right, can you all see that now?
Yes, wonderful.
Okay, so this I usually draw out in every consultation to kind of explain the different models. So if we start up here in the first third of the page, that's traditional litigation. And in the default matter, what you have is you have an attorney and client, you have 2 separate attorney-client relationships. And everything to do between the attorney and the client is privileged. Meaning if the client tells something to the attorney has to hold it in confidence unless they're specifically told they can share it. So you have 1 unit here and you have a 2nd unit here. And the way that there's an interplay is that this client talks to their attorney talks to the other attorney, who then talks to their client. And this is the chain of communication. And as we all know, a situation like that becomes a telephone game. It becomes distorted. This client, you know, this client's then going to speak to their spouse and they're going to say, well, your attorney said this. So this client's going to dislike this attorney and this client's going to dislike that attorney. And it creates a dynamic which is essentially unnecessary. People aren't hearing the same thing at the same time. Again, in some ways, attorneys are trained to create the storyline for their client and to promote that again and again to justify what they think should be the basis for the settlement. And it really polarizes people. And then what happens is this side will hire experts to support their position, and this side will hire experts to support their position. And so all you're doing is you're ending up with a battle of not only the attorneys, not only the clients, but also the experts.
Interesting.
That being said, there are cases that need to be litigated. I don't believe it depends on your net worth. I don't believe it's somebody with higher asset values or more complicated financials or parenting issues. I don't necessarily believe this produces a better result. What happens in this instance is, unless they come to an agreement, which by the way, most cases do, 95 to 98% of cases come to resolution without a trial. But to get there can be, prolonged discovery and lapse of time, which with the coronavirus is obviously even more exaggerated. Right now, the courts are not open to anything but priority one matters. So that's emergency-based issues, some of which are to do with motions for custody, some of which are to do with restraining orders and things like that. But the court has essentially suspended all hearings and trials at this point. So you are going to be looking at a long wait if you want to get in front of a judge. The other thing is, judges make mistakes. They are hearing a lot of different cases. They confuse the cases sometimes. They have 120 days to write an opinion. So some people imagine, like a Law and Order episode, it's not a jury trial, first of all. The judge makes the decisions. The judge can hear your matter, and then they have up to 4 months to issue a decision. People assume, the judge is going to speak from the bench, and it is very rare that the judge does that. So then if you look at the middle section of this page, there's the model of mediation. In mediation, you have one neutral professional. That mediator can be an attorney, it can be a counselor, it can be a certified divorce financial planner, depending on what your needs are. So that mediator works with both clients in a three-way process where the mediator helps get the clients to the point of resolution. They raise the issues that will need to be addressed. They help them work through it. Shall I admit somebody who's in the waiting room?
Yes.
Yes, please do.
Please do.
I didn't know. So in mediation, the mediator works with both clients together. Neither one of the clients do they represent individually. And that's really important. The process itself is confidential, meaning the mediator can't share that information with anybody else. But to the extent that one client shares something that's relevant or would be relevant to the other side, that mediator has a duty to either retire from the process or to share that information with the other client. The idea that it has to be full disclosure. So generally what you do is you meet in three-way conferences and you develop what you think are the provisions for the settlement. There's different ranges of mediators. Some people are more facilitative, which means if the parties come in and say, we both want a waiver of alimony and we want, a 90-10% split of the assets, which would be very unusual, that the mediator says, in that case, as long as you're sure, I will write that up for you and you can bring it in front of the judge. By the way, that's important. In any of the processes in Connecticut, you still need to have a judge approve your agreement. They have to find it to be fair and reasonable based on your particular circumstances, but it doesn't mean you avoid the judicial oversight. In a true mediation, the mediator will also encourage each client at some point to seek review counsel. And the role of review counsel is that they want to ensure that their own particular client understands the terms and has a knowledge and appreciation of what might otherwise be if they hadn't reached resolution. Their role is not to undo or to renegotiate the agreement. It's to make sure that their particular client is making an informed decision and that they've thought through the pros and cons. Hopefully the mediator themselves have already done that. So you have, the spectrum from facilitative to more evaluative. I think most mediators in this area are more evaluative. I make a point of telling my clients, you all can come to me and say you've had this discussion or this agreement, but it's my duty to go through with you and tell you the pros and cons. Because when you go to review counsel, I want you to feel invested and confident in the decisions that you've made. And therefore, if you come in and say we're both waiving alimony, that's fine. But I'm still going to explain to you what alimony is for, what the considerations are, and what the possibilities are. You can still have that agreement, but you need to know, right? In order to make an agreement, you have to be informed. You have to have all the information available. And so therefore, you're committing to it. That's the other real strength, I think, of mediation and collaborative, is when people are involved in this process, they're more committed to it. They're more invested in it. They've communicated, they've thought about why they came to this agreement, and they're more likely to stand by it. So there's less post-judgment issues that come up. There's less likely somebody's going to appeal anything. And also, you have the experience of modeling. So that in mediation or collaborative, because you're all sitting together and working off the same things, you're developing a way to communicate with one another that hasn't always necessarily been easy, given the fact that you're facing divorce. There are some criticisms of mediation that came out, which led then to the idea of the collaborative model down here. You might not be right for mediation if there's a big differential in power. If one person is very dominant and the other person is therefore subservient and gives in because they're avoidant of conflict. If there are issues that are very difficult to discuss and that a client might be hesitant to raise in front of the other party, whether it be an alcohol issue or a drug issue, or parenting style. And also, in my experience, if one party is completely unrealistic. I had a client come to me a couple of years ago, asked me to be the mediator, and she then sat down and explained to me why she needed X amount of money a month to continue to live in her house and raise her children as they always had been. And when I asked how much the spouse earned because there'd been a job change, et cetera, he'd earned considerably less than what she was even asking for in alimony. And so expectations of a client are very important. If someone comes in and they have very fixed mindsets about what they want, as a mediator, you can spend a lot of time trying to bring that person back to the middle and trying to educate them about what's more reasonable to expect. And oftentimes that party then feels you're favoring the other client, right? Because it seems like you're always saying, well, that probably isn't, reasonable, and you might want to think more about this. So because of those criticisms and some other ones, collaborative divorce evolved. And collaborative divorce is essentially a hybrid between traditional litigation and mediation. So in the collaborative process, you still have the direct attorney-client relationship, and that is a privileged relationship. So anything you share between the attorney and the client cannot be shared with the other side unless consent's given. And you also have that on the other side. And yet, instead of having the telephone game here, and instead of looking backwards to justify what you're asking the court to do, these attorneys, they're not co-mediators. They have identifiable clients but the attorneys are like-minded and they help the clients work together. However, instead of a mediator who can't give one side advice one way or the other, in this situation, that client has immediate access to their attorney. So if we're having a four-way conversation and an issue comes up and a client has a question about it, the client can say, can we step outside to discuss this further? And that's the same for both sides. The other thing is, by hearing what the other attorney is saying and the manner in which they conduct themselves, it makes the opposing client much more comfortable in the process. They don't need to demonize the other attorney because both, litigation again is focused on, quote, getting as much as you want in theory. Not always, but that's the model. Mm-hmm. In both mediation and collaborative, we don't start with demands. We don't start saying, well, my client wants this. Instead, we sit there and we talk to the clients and we say, what are your goals and what are your concerns? And a lot of times they're not mutually exclusive. They're not always aligned, but they're not mutually exclusive. So for instance, I had a client one time who came in and he and his wife had chosen collaborative. I had the husband, and the husband was a higher income earner. And I had gone through the whole consult with him. I talked to him about asset division. I talked to him about alimony. I talked to him about child supports. I talked to him about parenting plan. We had a good, good understanding or so, I thought. And I worked with this attorney a lot on the other side. And we went into the first four-way meeting. And my client, I guess with a heightened sense of bravado for some reason, turned around and said, well, I'm not paying you alimony. So if you want me to pay you alimony, we can just call this quits. And my client had been well versed in the fact that he was the higher income earner. She had not worked. There would be an alimony obligation. And it startled me because very few times have I had a client undercut me immediately in a negotiation to make a power stance. But in that position, not only did the wife's attorney say, well, okay, then we should stop the meeting. I also said, no, there is going to be an alimony component, or at least we have to discuss whether there's an alimony component. And it's likely not a matter of if, but a matter of what it might look like. So it took away some of the angst and friction and, to be honest, mistrust. People going through a divorce have reasons to feel alienated from their spouse on some level. And what you don't want to do is amplify that. What you want to do is harness the friction between the parties and try and manage it. Because overall, it will go a lot more smoothly. And I know that I'm out of my 20-minute time, but the last thing that I'll say about to compare mediation to collaborative is in the mediation setting, and the mediator is a neutral. So they will never represent either party in court going forward. In the collaborative model, if you talk about the true collaborative model, which I'm just believe there's only one, but there's also a clause that says in the event that you cannot reach an agreement and either party decides to go to litigation, neither of these attorneys are permitted to represent their own client going forward. It's called the disqualification provision. A lot of people get anxious about that and say, well, if I'm going to spend months negotiating with my spouse, what's to stop them from saying, I want to go to litigation and therefore we have to leave this process and now I have to start over again with a new attorney. And that is a concern, one that I really can't allay. On the other hand, I think of it also as the anchor. There are quite a few people that believe that when they are negotiating a deal, that they might get to a point where one party says, we've agreed on almost everything, but I'm going to live or die on my sword. And if you don't give in to me on this, then we're going to litigation. And it is a very powerful thing for the two attorneys to say, either one of you have that option to proceed to litigation. And what that means is we are no longer going to participate in this matter. So we're going to hand over your files. And even though you've gotten 95% of the way there, if you can't get over this last 5%, we're no longer going to be involved. And you're both going to have to go and get new counsel. And you're going to start from the beginning. Because until you have a full agreement on all the issues, there is no agreement. So a lot of times it keeps people planted at the table. Some practitioners agreed not to include the disqualification language, but in my opinion, that only means that you're back to this traditional model, and you're trying to play nice in the sandbox at school. But you always then have the threat of litigation, because at any point in time, that attorney can file a motion on behalf of their client. And without you even knowing, it's gone from a quasi-collaborative case to a traditional case. And in those situations, it becomes even worse, because where, in this situation, both clients have learned to, trust the mediator, hopefully, and or they've learned to kind of understand the dynamic between the attorneys here. If that attorney suddenly becomes litigious against the opposing client, it is not going to fare well in litigation. So that's kind of my overview. Oh, and at any time, by the way, parties can proceed pro se. You can either do it yourself and go to a mediator and ask them to vet it, and just say, can you help me write this up? Or can you tell me the pros and cons? Or I have people that come to me just as a consultant and say, will you just sit down and explain to me the concepts? And then I want to go back and talk to my spouse about it. But you are free to represent yourself. I do warn you, I had a colleague from law school who herself is an attorney, who went through a divorce, and she and her husband decided to address it together. He was also actually an attorney. They never addressed the issue of the house. Both the parties were on the house. They were both on the mortgage. She was moving for a job. He was going to stay in the house. They were going to share custody of the child. But the wife was still on the mortgage and the title and the note. And they never made any provisions for removing her from the house. So I don't remember exactly what the comment is, but I think it's if you're a lawyer and you represent yourself as a client, then you have a fool for a client. So, even if it's 20 minutes to vet it. And by the way, if you wanted to do it yourselves, there in every courthouse in the state, there's something called family relations. It's a free service provided by the court, and you can make an appointment and sit with them and have them help you vet it, or help you consider it. I don't believe it's going to be to the same in-depth review, but that is available and you can take advantage of that. And there are also other court services like judicial mediations. There's private judicial mediations. All of us mostly volunteer special masters, where we volunteer our services, and you can go and get an opinion from a special masters about that. So there's a number of different options, but I would say you would be well served if you actually, you would be well served if you actually explored those in the beginning, so that you know what your options are and you can talk to your spouse about it.
Can you, Darcy, can you go to family relations? This is from someone wrote in a question here. Can you go to family relations anytime?
You can. You have to, well, before COVID, yes.
That's right.
Right now, family relations is not taking on any new cases in terms of evaluations, custody evaluations. They are going to be available relatively soon through video conferencing. The courts in Connecticut, the state courts, I'm not sure about the federal. The state courts in Connecticut, it sounds like they're pretty committed to using Microsoft Teams. And they will start having virtual hearings. But as long as you have a case filed, you can ask to go to family relations. And in fact, if you have a pending motion, if you need an issue to be addressed before the final divorce and you were to file a motion with the court, for the most part, the judge is going to send you to family relations first before the judge will even hear your issue.
Gotcha. So the question coming in, can I request it or would my attorney? So so would an attorney go in and make a request for family relations, or would the person be doing it themselves?
It depends if you're represented by counsel on file. If you have an attorney who has an appearance in on your behalf, that attorney is going to be the one filing motions or requests, unless sometimes there's a hybrid where the attorney has a limited appearance in, but the party does as well. The courts want to know that there's one stream of communication. So if you are represented by counsel, they're familiar with the forms, they're familiar with the process, and they know the case flow coordinators. And so they can usually get you in much more easily. And again, if you have an attorney on record, that attorney would be present during any family relations consultation that you would have.
Gotcha. So I want to thank you, Darcy. That was like, so I could talk so much longer on this. I wish we had a lot more time. So thank you. That was a really kind of succinct job and laying everything out in a really organized way for everybody to kind of look at that. My question to you is, for children, in your experience, that when parents are doing their parenting, is that one of the major issues, or is it typically, do you find the financial? And then a secondary to that is, which plan, which format, whether litigation or mediation or collaborative, do you feel is would ultimately have a better outcome for the children?
Well, I think we tend to address the children's issues first. One of the first things that, besides the initial consult, whenever I'm meeting with a client, what we try and look at first is the parenting plan. Mm-hmm. It's assumed in Connecticut, presumed that you're gonna have joint legal custody, which means decision-making for the children, unless there really are unusual circumstances that would demand otherwise. I have had clients come in and say, well, I want sole legal custody because my spouse isn't involved, or my spouse leaves it all up to me anyway. In which case I said, don't argue it. Just by default, it's going to be your decision. I would say that it is only contested custody cases that really require anything other, or a request for anything other than joint legal custody. But again, well, I guess because I'm more bent towards mediation collaborative, I'm more bent toward family oriented. But those are the first things I do. And when people come in and say, I want equal parenting time, I say, forget that. You're not counting hours. Your children aren't with you 12 hours out of 24 hours. And forget the posturing of, I want this, or I want to be primary, or I want equal time, or they don't want to pay child support. You start with the schedules. I mean, that's what I say to people. What does your day look like? What time do you go to work? What time does your spouse go to work? What time do you get home? What are the children doing? And to really focus it on what's the natural functionality, I guess, of the children and the family. It will be different, given that there might be two households going into the future. Mm-hmm. But right then you're beginning to say, what's good for these kids? How can we address it? How can we make the transitions more smooth? And I would say that, mediation and collaborative, that's where you tend to bring in one, if you need assistance, you tend to bring in one family therapist or one co-parenting counselor to help you get through some of the more difficult issues, but the parties are hiring them together and they're part of the team approach. And therefore, they're neutral in and of themselves. In the litigation process, it's going to be the opposite. Each party is going to hire their own expert to describe what they believe is appropriate. Frequently the court might make an appointment for a guardian of the minor child, depending on if they're toward a younger age, or an attorney for the minor child if they're more mature and their voice should be heard. But it becomes binary, right? In those situations, the parties are giving the court permission to decide in one party's favor or the other party's favor. And believe me, the judge does not have to do, the judge can design whatever he or she believes serves the best interest of the children. So if the husband says, I want sole custody, and the wife says, I want sole custody, it doesn't mean that the judge only has those two decisions. They can create it, and it should be personalized to their situation. But again, you have a lot of he said, she said, where hopefully in mediation or collaborative, you're on track to resolve the issues, not fight over whose position is better.
Gotcha. All right. Thank you for that. That was good. I'm going to open it up. Does anybody else have any questions for Darcy?
Yes, I have a quick question. Under what conditions does a child, what are the most common conditions where a child custody evaluation gets ordered?
Almost always in the case of abuse. If there's allegations of abuse toward the child or mental illness, oftentimes if there is, there's a plethora of reasons. If there's substance abuse issues, it can be ordered. If one party is wishing to relocate, in that scenario, the court has a whole bunch of factors to consider. And one of which is, where's the child going to be better served? And on the contrary to that, how is that going to impact the relationship they have with the other parent? So I've seen them ordered if there's medical issues to do with the child, if the parties don't agree on it, but really in highly contested issues. If somebody believes that one of the parties poses a risk of danger to the child, danger or neglect, if DCF has become involved, if there is police intervention, sometimes you still don't need that. Sometimes everyone can kind of take their breath and sit down and try and refocus and figure it out. But any significant parenting issue that one or the other party decides is prominent enough that they ask the court for that evaluation. And that's the thing. It can, as you have more and more professionals and more unwilling professionals, let's say that, or court-appointed professionals, they're going to have an opinion, and then the other side often feels the need to respond to that and say, well, that's not the case. He or she's biased against me or didn't consider this. And it becomes prolonged. It becomes expensive and it becomes prolonged. Versus saying to both parties, this person is this goal or this, or this concern, and we need to address that concern. And if we can address that concern, then it doesn't need to be a dramatic result in one party's favor or the other. I had a client years ago where the wife was accusing him of having an alcohol issue. And he did have to socialize a lot for work. And I think that, so he volunteered. He said, I'll do testing when I have the children. I'll do testing before I get the children. I'll do testing in the middle of my weekend and at the end of the weekend for a limited period. He didn't, he wasn't drinking with the children. He was fine. But that was going to be, and he proved it because he had the monitoring and all of that. However, that was going to be like a do or die issue. The white, and at some point, a lot of judges will say, I don't mind if you drink alcohol as long as you don't do it when you have the children, right? It comes back to the children. The courts are not overseeing everything that you do. If you have drugs in the house, that's going to make a difference. But if you have a couple drinks at night and you're not driving and you don't have the children, the court doesn't really oversee that. So part of it depends on the issues that would be presented. Part of it depends on how vigorously one party wants to make it an issue.
Now, we do have,
questions, Suresh?
I'm sorry, there is a question coming in on the chat. And the question is, what if there is a closed DCF case?
Okay, well, I'm not sure. Okay, so there's 2 steps to DCF cases. One of which is they first interview everybody and make a determination about whether or not the allegation is substantiated. Okay, that just means whether or not there's enough evidence to show that something occurred that posed a risk of injury to the child. If it's substantiated, there's then an investigation, and there can then be an evaluation by Department of Children and Family Services and recommendations given. Or on the other hand, they might initially substantiate it, then they might do an investigation and decide that either there's insufficient evidence to have to go further, it's unnecessary, or it was a one-off, in which case they might close the DCF file, which means that it's not an active file and there's no intervention or oversight being given by Department of Family and Children's Services. So those are 2 different things. Once you have involvement by that agency, the attorneys or the parties should be very quick to bring it into the family law case. Again, asking for orders. I was speaking to a client today. She had a restraining order against her husband, and she was considering letting him see the children and relaxing it, but this is all brand new. And one of the things that we talked about was taking it in steps, getting counselors involved, getting therapists involved for the kids, getting co-parenting specialists involved to help work through it. I mean, there are different gradients of what is a risk to a child. A risk to a child could be leaving the stove on, versus a risk to a child could be that one of the parents has an active drug problem and is using, is incapable of supervising the child. So there is a difference between a closed DCF case and substantiated or unsubstantiated. But you can subpoena those records, you can subpoena the caseworker and their observations, and that will be considered by the court.
Well, I think, Darcy, with everything with divorce, it's always full disclosure when you have children anyways, whether it's to family services or to each party or to the attorneys, like you really want to put everything out there anyways, because that's how you're going to make the best determination, right? And so typically I would imagine the courts would find out if there was a DCF case anyways. Is that correct? Even if it's closed, right? Wouldn't it be brought up?
The judge is not independently going to inquire.
No, not the judge, but wouldn't family services?
If somebody raised it.
Yeah.
It's not a typical Canvas question, has it ever? I mean, if somebody raises the issue of, I believe he drinks too much, somebody might say, well, have you ever reported it? Has there ever been a police report? Has there ever been a DCF investigation? But really, it's kind of incumbent upon the parties and or the attorneys to raise it.
Gotcha. All right, is there any other questions for Darcy before we wrap? John, you have anything?
No, thanks. No, excellent work.
Okay.
I appreciate it very much.
So Darcy, what's your, can we put your email or contact information if anybody wants to call you, contact you, do a consultation with you? Can I put your contact information in our chat? Can you tell me what it is?
Sure. My office phone is 203-202-3120. Be aware that we have limited people going into the office right now, but I will get your voicemail and respond.
Okay, great.
Or my email is Darcy, D-A-R-C-Y,
Yep.
at C like car, M like Matt, M like Matt again.
Could you repeat that again? Darcy, D-A-R-C-Y, what was it?
At C like car,
Okay, yep,
M like Matt,
yep,
M like Matt again,
okay,
hyphen law.com.
okay. All right. I'm going to put that in the chat, and if anybody wants to come in for a consult or speak with you further, they can contact you.
Sure. There's actually one other person that commented that I just want to address before
Sure.
we, it was an inquiry about whether somebody needs an attorney to subpoena,
Okay.
I assume DCF records. You don't have to hire an attorney. You have to go through the clerk's office, and they can help you with a subpoena, and then you'd have to have it served on the party, et cetera, et cetera. So you can do it yourself, but you need to do it in conjunction with the clerk of the courthouse. And just right now, it's difficult to get into the clerk. So you're actually not permitted to go into the clerk's office, but hopefully we will be over time. I mean, we're in an ever evolving situation. So a lot of the things that I could tell you easily how to do it, they're still trying to figure some of those things out. But yes, pro se litigants, people that are self-represented, have all the same rights and tools available as would an attorney.
Awesome. Okay. Well, thank you, Darcy. Like, that was so helpful, and just kind of really, I appreciate your even diagram. That's actually a great diagram to have. You should make it as a template. Like, it's good
I know,
stuff.
I should make it formal instead of just my scribble.
No, you did good. Good handwriting, good
I was
printing.
gonna say, you can see my horrible handwriting.
All right. Well, thank you, everybody. Again, Attorney Darcy McCallister. You're located in Darien.
Yes.
So if you need to contact her, you can see in the chat, we have her number 203-202-3120. And I'm going to put up her contact email in a sec. And find us on Shared Parenting on Facebook, or you can find us on Shared Parenting, our website, Shared Parenting of Connecticut, or Council of Connecticut. And thank you, everybody, for coming, and catch our next one. We're going to take a little hiatus for the month of July and August, and then we will probably resume back in September. But if you need anything in the interim, contact us at Shared Parenting, or contact me at mediationandbeyond.com, and we'll look forward to helping anybody out. Thanks again.
Thanks, everybody.
Thank
For all
you.
the work that you do.
Yes, thanks.